Good morning, everyone. We'll start with Contract Act. इसमें पहले आप जो थोड़ा बहुत इम्पोर्टेंट है वो आप मार्क कर लीजिएगा, जो आपको प्रीलिम्स के लिए तो करना ही पड़ेगा, वो आप एक बार मार्क कर लीजिए. सेक्शन नंबर 2 इंटरप्रिटेशन क्लॉज. ओके, उसमें सारे आपको पता होना चाहिए, कौन से A to J तक है सारे, वो आपको पता होने चाहिए प्रॉपर्ली. फिर ये कम्युनिकेशन वाला जो पार्ट है वो एक बार देख लेंगे. But what contracts are void, voidable, void agreements, right? That you must know. What is consent? What is pre-consent? Coercion, undue influence, fraud, misinterpretation, right? This you must know. Contingent contracts. Okay. Then there is this portion, performance of reciprocal promises. Doctrine of frustration, section number 56. दूसरे आपको वैसे 75 सारे रटे हुए ही होने चाहिए. Okay, but these few things pay attention more. Quasi contracts, chapter number 5. The contracts which resemble those, means the relations which resemble those created by contracts. Acha. And section chapter number 6. What are the consequences by breaching a contract? Now, indemnity, guarantee, bailment, agency. Okay, you must know them. What is bailment? What is a guarantee? What is indemnity? What is agency? ये सब पता होना चाहिए. इसमें sections बहुत ज़्यादा है, बहुत इतना डेप्थ में जाने की ज़रूरत नहीं है, पर सेक्शन 75 तक सब प्रॉपर याद रखना है. इंडेमनिटी और गारंटी में सेक्शन नंबर 124, 125, 120, वही सारा 124 से लेके 131 तक प्रॉपर यू मस्ट नो, राइट. देन सेक्शन नंबर 148, बेलमेंट, बेलर, बेली क्या होता है, राइट. Otherwise, just go through it. What is the right of finder of goods? May sue for specific rewards of offered. Sorry. When finder of a thing commonly on sale, he has the right to sell it off. बेली का क्या पर्टिकुलर लियन है, राइट. ये सब पता होना चाहिए. प्लेज 172, पॉनर एंड पॉनी. Then go directly to 182. एजेंट एंड प्रिंसिपल डेफिनेशन है. Consideration not necessary, section number 185. Sub agent ka definition 191. Okay, see there are many sections in this, 182 से लेके 238 तक, right. Partnership भी था, but now we have a separate partnership act. We'll do it after contract act. We have less time, and now even prelims is just hardly few days. So जितना मैं बोलती हूँ उतना एक बार आप देख लीजिएगा. That's it. Okay. 1/9/1872 it came into force, right. Remember that. Now come directly applicable everywhere. Okay, commencement or extent इसका पता होना चाहिए. Interpretation clause, section number 2. Now every clause A, B, C, D आपको ऐसे पता होना चाहिए. 2A, 2B, 2C, 2D, 2J तक आपको सारे पता होने चाहिए. Okay, they come in prelims. So the first interpretation clause 2A, when one what is a proposal, right. When one person signifies to another person his willingness to do or to abstain from doing anything, right, with a view to obtain the assent of the other to such act or abstinence, he is said to make a proposal. So first you make a proposal, right. Then after proposal, what happens? when the person to whom the proposal is made, he signifies his assent, means he gives his confirmation, thereto the proposal is said to be accepted. So P plus A. Okay. So proposal plus acceptance, right? Then a proposal when accepted becomes a promise. Remember that. So P plus A is equals to promise, right? आप इस तरीके से अपने बुक में लिख लीजिएगा, right? Now, after it becomes a promise, the person who makes the proposal, उसको हम promiser कहेंगे, और जिसने accept किया उसको हम promisee करेंगे. So P plus A plus P, वहां पे promise हो गया, right? और promise में ही आप दो arrows लगा दीजिए, promiser और promisee कर दीजिए, right? फिर उसके अंदर हम consideration add करेंगे, right? So when at the desire of the promiser, right, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such an act or abstinence or promise is called consideration for the promise, and it is not consideration for the proposal, it is consideration for the promise. So P plus A plus P plus C, ऐसी तरीके से आप याद रखिएगा. Every promise and every set of promises which forms the consideration for each other is an agreement. So then it becomes an agreement, right? When an agreement is enforceable by law, then it becomes a contract. 2H, right? So अपने अपने बुक में ऐसी तरीके से आप लिख दीजिएगा, P plus A plus P plus C plus A, then it becomes a contract, right? It's very simple. Contract act is very simple. It's nothing very high tech or scientific इसमें कुछ नहीं है. It's very simple. मैं आपको जिस तरीके से बोली हूँ अपने बुक में लिख दीजिए ऊपर, जो आपकी बेयर एक्ट है. It will be simple, right? Then what is a reciprocal promise? Promises which form consideration or part of consideration for each other, they are known as reciprocal promise. इसके बदले ये दे, इसके बदले ये दे, right? So agreement plus enforceability is equals to contract. When the agreement is enforceable by law, just not normally enforceable, it has to be enforceable by law, then it becomes a contract. But an agreement which is not enforceable by law, that is void. So that agreement is void agreement. Okay. What is a voidable contract? An agreement which is enforceable by law at the option of one or more of the parties, but not at the option of the other party or others. Then it is a voidable contract. So there can be a void, there is a void agreement, there is a void contract, and then there is a voidable contract. Okay. Then there is a valid contract also. How does a contract becomes valid? When it is enforceable by law, then it is a valid contract. So 2H is valid contract. 2I is a voidable contract. Okay. Then a contract which ceases to be enforceable by law, means उसकी enforceability cease हो चुकी है, खत्म हो चुकी है, then it becomes void when it ceases to be enforceable. So remember one thing, contract can be a valid contract, there is a voidable contract, and there is a void contract also. But agreement जो होता है वो सिर्फ void होता है. Okay. Remember that 2G, 2H, 2I and 2J, these are all important. Okay. See, for prelim perspective, just write down, make two columns. एक तरफ agreement लिखिए, दूसरी तरफ contract लिखिए. An agreement can be valid and an agreement can be void. But a contract can be valid, it can be void, it can be voidable. Okay, तीनों चीज होती है. So there is nothing known as a voidable agreement. If it comes in the prelim as an option, voidable agreement, कोई concept है ही नहीं voidable agreement. Okay, an agreement is on the face of it void, or it can become valid, right? But there is nothing known as voidable agreement. See, there are many case laws with respect to contract act, like Balfour versus Balfour, Bolton versus Jones. But I have seen one thing that अपने गुजरात जुडिशरी में बहुत सारे case laws पूछे नहीं गए हैं. Okay, so if you have to study case laws, then case laws will be there in Contract Act, in Evidence Act, as well as in Partnership Act, as well as in what we say IPC, right? And if you go to study so many case laws, uh, you will just go berserk. So what I personally advise is, even if a case law comes, a question with respect to, means, a very smart study has to be done with prelims, right? If you will try and mug up many case laws, you will be wasting your time. कितने questions पूछेंगे case law से related? Like they'll just put a case law, right? जैसे कि offer और acceptance को लेके, there a landmark judgment is Bolton versus Jones, right? So if they ask, well and good, but कितने पूछेंगे? They'll just put it as Bolton versus Jones is with respect to which concept. That way they will put it, right? So then there is creating legal relations, right? That is Balfour versus Balfour. ऐसी तरीके से वो लोग डायरेक्टली कुछ रख देंगे, but not necessary ना that you have to answer all the 100 questions. That's what I'm trying to say. So if you can remember the case laws which are given in your comments in your Bear Act, well and good. If you don't remember, I would not say that, break your head on trying to mug it up. Because if you will try to mug this up, then what about the other subjects? So don't waste your time in all that, right? Then there is the concept of communication, acceptance, and revocation of proposals, right? So what is a communication? Communication, section number 3, communication, acceptance, and revocation of proposals. The communication of proposal, the acceptance of proposal, and the revocation of proposal, as well as the acceptances, respectively, are deemed to be made by any act or by an omission. Omission means nahi karna, act means karna, right? So by any act or omission of the party who proposes it, who accepts it, or who revokes it, by which he intends to communicate such proposal, such acceptance, or such revocation, or which has the effect of communicating it. देयर इज नथिंग. तो ये बोल रहा है जो पार्टी एक्ट से या ओमिट करने से, वो जो मींस बाय एन एक्ट ही कैन शो दैट ही इज प्रपोजिंग इट, और बाय नॉट परफॉर्मिंग द एक्ट he can say that he has omitted to perform it. So just remember that. So by an act or omission, he can by the party who proposes it, who accepts it, or who revokes it, or who intends to do the same. Communication को कब complete माना जाएगा, right? Communication of a proposal is complete when it comes obviously to the knowledge of the person who is made, to whom it is made. somebody, अगर काजल ने चाहती थी मुझे proposal पहुंचाने के लिए, so when it comes to my knowledge, then it will be said that the communication of the proposal is complete. So basically it has to come to the knowledge of the person to whom it is made. Then we'll say that the communication of proposal, यानी कि offer, proposal means offer only, okay? So it is complete. So you can just put a slash with proposal, offer, दोनों चीज same है, offer या proposal. अब कम्युनिकेशन ऑफ एक्सेप्टेंस कब कंप्लीट माना जाएगा? ओके, ये तो सिर्फ कम्युनिकेशन ऑफ प्रपोजल कंप्लीट हुआ है उसके नॉलेज में. अब एक्सेप्टेंस को कब कंप्लीट मानेंगे कि वो कम्युनिकेशन ऑफ एक्सेप्टेंस इज कंप्लीट एज अगेंस्ट प्रपोजर, यानी कि एज अगेंस्ट काजल जिसने प्रपोज किया था, उसके अगेंस्ट कब कंप्लीट मानेंगे? व्हेन इट इज पुट इन द कोर्स ऑफ ट्रांसमिशन टू हिम सो एज टू बी आउट ऑफ द पावर ऑफ द एक्सेप्टर. यानी कि मैंने द पर्सन हु हैज प्रपोज्ड इट, उसके अगेंस्ट मींस उसके तक कब हम मानेंगे कि कंप्लीट है? जब ऑन द वे आ गया है. मींस आई हैव कम्युनिकेटेड माय एक्सेप्टेंस, देन आई कैन नॉट डू एनीथिंग afterwards when I have already transmitted the communication. As against acceptor, यानी कि मेरे अगेंस्ट, when it comes to the knowledge of the proposer, means it has to come to the knowledge of Kajal ultimately. See, ये दो तीन चीजें तो आपको बहुत अच्छी तरीके से याद रखना पड़ेगी. इसके सारे जो illustrations है, we do not have time to go into depth of everything because we are just giving you a kind of a brush up with all the sections. Still, I'll run through all the sections, but if I go, there are many illustrations in Contract Act. If we sit to do every illustration, we will not complete anything, right? So illustrations I'm leaving up to y'all, and what we say, even the case laws, if you all wish to do, मेरे को जहाँ पे लगेगा एक दो ऐसे बताने के लिए मैं आपको बता दूंगी, right? But we do not have that much time to go into every illustration, into every case law. We cannot complete the course then, right? I won't be able to mark the important part for the other subjects then for you. if I just stick with Contract Act. I can stick with Contract Act till the 15th of May also, but then we can't do the other acts. Communication of revocation कब complete, यानी कि revoke कर दिया है communication. So as against the person who makes it. So the person, anybody can make it, either the proposer or the acceptor, right? When it is put into the course of transmission to whom it is made, so as to be out of the power of the person who makes it. If he has already put it into the transmission, right? फिर उसके बाद वो ऐसे अचानक से डिसाइड नहीं कर सकता, यार यार नहीं नहीं नहीं, आई कैन नॉट, मींस आई वांट टू विड्रॉ माय रिवोकेशन. ही कैन नॉट डू दैट because once he has already put it into the transmission, he cannot revoke it, means he cannot take it back. As against the person to whom it is made, when it comes to his knowledge, obviously it is complete, then ऐसे माना जाएगा. Now section number, see, there is the entire illustration. बहुत अच्छी तरीके से इन्होंने बताया है. A proposes by letter to sell a house to B at a certain price. The communication of the proposal is complete, obviously, कब? When B receives the letter, right? अब ये accept, अब A वाला जो था वो proposal complete कब माना जाएगा? अब acceptance कब माना जाएगा complete, right? कि ये बंदे ने accept किया है. So B accepts A's proposal. B ने accept कर लिया है by a letter sent by post. वो post कर देता है. The communication of acceptance is complete as against A, यानी कि proposer, when the letter is posted. Means transmission में आ गया. As against B, when the letter is received by A, right? A revokes his proposal by telegram. A decide करता है कि नहीं, मेरे को अब I am not interested to sell this house to B. So he wants to revoke his proposal by telegram. So the revocation is complete as against A when the telegram is dispatched. But it is come into transmission. So as against A, now A cannot take back his step. And it is complete as against B when B receives it, right? So just keep this in mind. Please go through the illustrations by yourself. I just went through it once, but just go through every illustration properly, right? Now, revocation of proposal and acceptance, dono. A proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards, right? Means a proposal may be revoked at any time. कभी भी वो proposal अपना revoke कर सकता है before communication of acceptance is complete. Means जो जिसको propose किया है वो अपना acceptance proposer को भेज दे, right? और उसके तक पहुंच जाए, उसके पहले वो कभी भी अपना proposal revoke कर सकता है. Or else the proposer is bound when he gets his acceptance. And acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards, right? It's the same thing. Proposal तो किसने भेजा है? Proposer ने. और acceptance obviously the person जिसको proposal भेजा है उसको करना है. तो वो दोनों के against कब complete माना जाएगा? Means before the communication of acceptance is complete, and यहाँ पे before communication of acceptance is complete as against the acceptor, and वहाँ पे before the communication of acceptance is completed as against the proposer. So ये दो चीजें आप याद रखना सेक्शन, पर इसमें सबसे इंपॉर्टेंट है सेक्शन नंबर 4, वो अच्छे से आप याद कर लेना. रिवोकेशन के क्या क्या तरीके होते हैं, किस तरीके से आप कर सकते हो? नोटिस के तरीके से. दूसरा, टाइम लैप्स हो गया है प्रपोजल को एक्सेप्ट करने के लिए, वो टाइम लैप्स हो गया है. सो जो रीजनेबल टाइम दिया था, प्रेस्क्राइब टाइम दिया था, उसमें आपने कम्युनिकेशन ऑफ एक्सेप्टेंस नहीं किया था. सो फर्स्ट इज नोटिस, सेकंड इज टाइम लैप्स, थर्ड इज कोई कंडीशन प्रीसिडेंट दिया था एक्सेप्टेंस को फुलफिल करने के लिए, वो आपने कंडीशन प्रीसिडेंट फुलफिल नहीं किया. सो दैट आल्सो लीड्स टू द रिवोकेशन ऑफ प्रपोजल. फोर्थ इज कोई भी डेथ या इंसैनिटी ऑफ द प्रपोजर, if the fact of this death or insanity comes to the knowledge of the acceptor before accepting it, right? So this all leads to the revocation of the proposal. Notice, time lapse, there is a condition precedent given for acceptance but it is not been performed, and lastly the death or insanity of the proposer, and it comes to the knowledge of the acceptor before acceptance. Acceptance must be absolute. This is a mains question, very good mains question, right? So acceptance must be absolute in order to convert the proposal into a promise. We said, right, P plus A is equals to promise, right? Means proposal plus acceptance will lead into a promise, right? Then it becomes, then we add consideration to it, then it becomes an agreement, and then it becomes a contract, right? But तो यहाँ पे क्या कहते हैं कि acceptance just cannot be haywire, it cannot be vague, it has to be absolute. So in order to convert a proposal into a promise, the acceptance must be absolute and unqualified, यानी कि no counter offer. कोई दूसरा सामने से ऑफर दे रहा है, ऐसे वैसे कर रहा है, तो वो हम नहीं कहेंगे. मीन्स दैट डज नॉट लीड टू एन एब्सोल्यूट एक्सेप्टेंस. It has to be accepted on the face of it, how it has been proposed by the proposer. Then, first you write down absolute. Second, you write down unqualified. Third, it has to be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it has to be accepted and the acceptance is not made in such a manner, the proposer may, within the reasonable time after the acceptance is communicated to him, insist that the proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, means the proposer fails to do so, means proposer fails to pass on the message to the person who is accepting it, it will mean that he has accepted the acceptance. So इसमें चार चीजें हैं. Acceptance must be absolute, acceptance must be unqualified, means कोई qualify, means ये तौर तरीके दिए नहीं जाने चाहिए. वैसा absolute, unqualified, it has to be expressed in some usual and reasonable manner, means पता चलना चाहिए कि हमने accept किया है, right? और अगर कोई prescribed manner दिया है, पांचवा point, तो वो prescribed manner में वो acceptance करना पड़ेगी, right? So these are the 5 things for section number 7. Now acceptance by performing a condition. कैसे acceptance किया जाएगा? Acceptance by performing a condition or receiving consideration. Performance of the conditions of a proposal or acceptance of any consideration for a reciprocal promise which may be offered with a proposal is acceptance of the proposal. तो किस तरह आप यहाँ पे क्या करोगे? By performance. कोई conditions attached हो, नहीं तो with consideration. Means कुछ consideration, यानी कि money देना. Supposing money is also a consideration only, right? So आपने money दी, वो proposal को accept करा, लेकिन वो acceptance के साथ आपको मनी अगर देना पड़े तो वो by receiving the consideration, by paying the consideration to the proposal. So that is it. So यहाँ पे आप लिख दीजिए सेक्शन नंबर 8 में आप इसके साथ बहुत लैंडमार्क जजमेंट आप बोल सकते हो, कार्लिल वर्सेस कार्बोलिक स्मोक बॉल कंपनी वाला केस. सो प्लीज कीप दिस इन माइंड फॉर दिस पर्टिकुलर सेक्शन, कार्लिल वर्सेस कार्बोलिक स्मोक बॉल केस, राइट? So इसमें first is you either perform the conditions which are attached with it or by you paying the consideration. Section number 8. Promises can either be expressed or it can be implied. In so far as the proposal or acceptance of any promises is made in words, the promise is said to be expressed. So when it is made in words, you will say that the promise is expressed, right? And in so far as the proposal or acceptance is made otherwise than in words, यानी कि कोई symbolic तरीके का हो, right? Then you will say it is implied. So that is by a conduct. Implied promises means by conduct, and express promises by words, right? So it can be some positive act of the, how will you say it is an express promise? It will be some kind of a positive act of the offerer, means like by word of mouth or by writing it down or something which is expressive, right? So that you will say promises can either be expressed or it can either be implied. Now, of contracts, of voidable contracts, and of void agreements. What agreements become contracts? They are saying all agreements are contract. Lekin, in order to translate from being an agreement to a contract, they have to be made by free consent of the parties. The parties must be competent. So first point, free consent. Second is competency. आप लिखते जाइए side by side. वहाँ पे already लिखा ही हुआ है अंदर. But if you wish to write 1, 2, 3 ऊपर ऊपर, तो आप लिख दी, वहाँ पे आप लिख सकते हो free consent. जहाँ पे लिखा है वहाँ पे number 1, competent to the contract means competency of the parties. Number 2, lawful consideration होना चाहिए. Number 3, lawful object होना चाहिए. Number 4, right? And And lastly, number 5 is it cannot here be expressly declared to be void. Number 5. Okay, so these 5 things will lead an agreement to a contract. Means अगर ये चीजें है ingredients, then these essentials, if these ingredients are fulfilled in an agreement, then the agreement becomes a contract. Nothing herein contained shall affect any law in force which is in India, and not hereby expressly repealed, by which any contract is required to be made in writing or in the presence of witnesses, or any law relating to registration of documents. इसका मतलब क्या है, अगर कोई लॉ एग्जिस्ट करता है इंडिया में जहां पे वो लॉ ने बोला है कि ये एग्रीमेंट को कॉन्ट्रैक्ट में हम तब मानेंगे अगर वो राइटिंग में हो या साइंड हो या विटनेसेस के प्रेजेंस में किया गया हो या रजिस्ट्रेशन किया हो, तो अगर कोई लॉ ऐसा डिमांड करता है कि दीज थिंग्स शुड ऑल्सो बी देयर, देन यू हैव टू फुलफिल देम, then only your agreement can become a contract. Who are competent to contract? They're saying everybody is competent to contract, but majority honi chahiye, secondly sound mind hona chahiye, and he should not be disqualified by any law which is in force. So these 3 things actually, these subjects which we are teaching is just kind of a revision thing. We all expect that you all have read them before, right? So this is just kind of a revision which has been going on. There cannot be anything like you all are learning new from it, because obviously when there are just 20 days remaining for prelims, it is impossible that this is the first time you are opening the contract act. I'm assuming, and even Aftab bhai and everybody is assuming, that you all have already read these subjects in advance, right? Now, what is a sound mind for the purpose of contracting? Okay, means he should be capable of understanding it, and he should be capable of forming a rational judgment, right, as to its affect its own interest. Means it should not affect, it should not give any side effects to his own interest or to the opposite party. So he should be capable of understanding, and he should be capable of making rational judgment. नाउ ये इंपॉर्टेंट है, अ पर्सन हु इज यूजुअली ऑफ साउंड अनसाउंड माइंड, वो वैसे ही पागल आदमी है, बट ओकेजनली वो साउंड माइंड का होता है. ही मे मेक अ कॉन्ट्रैक्ट व्हेन ही इज ऑफ साउंड माइंड, यानी कि वो जब साउंड, ये इंपॉर्टेंट है, राइट? वैसे वो यूजुअली अनसाउंड माइंड का है, लेकिन कभी कभी दौरे पड़ते हैं जब वो साउंड माइंड का होता है, और वो सिर्फ साउंड माइंड का है, वो कॉन्ट्रैक्ट करना चाहता है, तो वो कॉन्ट्रैक्ट कर सकता है. और पर्सन जो यूजुअली साउंड माइंड का है, वैसे तो वो अच्छा है, अच्छे दिमाग का है, लेकिन ओकेजनली अनसाउंड माइंड का है, तो ही मे नॉट मेक अ कॉन्ट्रैक्ट व्हेन ही इज ऑफ अनसाउंड माइंड. ओके, दिस इज वेरी लॉजिकल. यू विल डेफिनेटली अंडरस्टैंड. जो यूजुअली साउंड माइंड का है लेकिन कभी कभी अनसाउंड पागल हो जाता है, ओके, तो वो जब पागल होता है वो तब कॉन्ट्रैक्ट नहीं कर सकता है. जो एक्चुअली पागल है पर वो जब कभी कभी मीन सेन होता है, राइट, he can make a contract. That's what they are saying. Consent को क्या definition दिया है? See, now this is very important. 13 is just consent, but 14 is free consent, right? So two or more persons are said to consent when they agree upon the same thing in the same sense. Consensus ad idem जो बोलते हैं, right? Meeting of the minds, वो होना चाहिए section number 13. So just write down consensus ad idem, CONSENSUS. Consensus ad idem, IDEM, means meeting of minds. Meeting of minds zaruri hai, they are saying, as per section number 13. But section number 14 says consent is okay, but consent को कब free consent माना जाएगा? अगर ये कोई चीजों से cause नहीं किए हो, coercion, undue influence, fraud, misrepresentation या mistake, CUFMM. Okay, so you can remember it like this, CUFMM. Okay, consent is said to be so caused when it would not have been given but for the means वैसे तो consent नहीं देता, but ये सारी चीजें है, राइट, इसलिए उसका जो फ्री कंसेंट जो वो दे सकता था वो हार्म हो गया. बट ये सारी चीजें आ गई, किसी ने धमकी दी, किसी ने अनड्यू इन्फ्लुएंस किया, किसी ने फ्रॉड किया, कुछ मिस रिप्रेजेंटेशन किया, कुछ मिस्टेक हो गई, तो उसकी वजह से उसने कंसेंट दे दिया. सो देन हिज फ्री कंसेंट इज मार्ड, एंड दैट इज व्हाई यू विल से दैट इज नॉट अ कंसेंट. अभी ये सारे 13 14, अब 15 आप सेक्शन नंबर 15 जो है वो कोअर्जन है. कोअर्जन क्या चीज होती है? Coercion is the committing or threatening to commit any act which is forbidden by the IPC, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of any causing any person to enter into an agreement. तो आप उसको थ्रेटन करते हो कि भाई मैं आपके अगेंस्ट ये एक्ट करूंगा, जो कि ऑलरेडी फॉरबिडेड है आईपीसी में, या मैं कोई आपकी प्रॉपर्टी जो है वो मैं डिटेन कर लूंगा. यू आर थ्रेटनिंग अनलॉफुल डिटेंशन या डिटेनिंग with the intention only to cause that other person to enter into an agreement. So you are coercing, right? धमकी देना यहाँ पे जो कहते हैं कि मैं आपके अगेंस्ट ये एक्ट करूंगा या मैं आपकी ये प्रॉपर्टी जब्त कर लूंगा. So then you are saying that you are practicing coercion on the other person, and that is why the other person got afraid ये धमकी की वजह से, और उसने अपना कंसेंट दे दिया. So basically उसका जो फ्री कंसेंट था वो उसने परफॉर्म नहीं किया. Just why? Because of coercion. So explanation: it is immaterial whether IPC is or is not in force in the place where the coercion is employed. It is immaterial बोला है. Whether IPC is or is not in force in the place where coercion is employed, not necessary. ये आप इसका illustration देख लेना. A on board an English boat, A on board an English ship on the high seas causes B to enter into an agreement by an act amounting to criminal intimidation under IPC. A afterwards sues B for breach of contract. Okay.
मैम आप म्यूट हो गए.
Okay. So A afterwards sues B for breach of contract at Calcutta. Now, इसमें क्या है? A ने employ किया था coercion. Although his act is not an offense by the law of England, and although Section 506 of IPC was not in force at the time when or the place when the act was done, right? It does not matter कहाँ पे किया, whether वहाँ पे ये law applicable है या नहीं है, right? They are saying that only. A threat of suicide also amounts to coercion under section number 15. ये एक केस में held किया था. Just remember that. Section number 16, undue influence क्या कहते हैं? Okay. Undue influence means यहाँ पे क्या होता है? Relations exploit किए जाते हैं. Relations are exploited basically. Okay. You are dominating the will of the other person. Why? Because you are in such a position. Maybe I am in such a rank. I am in such a position that I can, make my servant do anything for me because I am employing undue influence on her. The master can do this for his servant, right? So that's what they are saying. A contract is said to be induced by undue influence where the relations subsisting between the parties, yani ki the relations which are existing between the parties are such that one of the parties is in the position to dominate the will of the other party, and he uses that particular position in order to obtain an unfair advantage over the other, right? So yahan pe relations are being exploited. You are in such a position to actually dominate the other person, and because of that the other person feels obliged that हाँ यार देखो ना मैं तो इसका नौकर हूँ, मुझे करना ही पड़ेगा. That is why. So basically you are doing all this in order to gain some kind of benefit, in order to gain some kind of an advantage. That is undue influence. Section number 16. In particular, and without prejudice to the generality of the foregoing principle, a person is said to be in a position to dominate the will of the another. Firstly, A, when he holds a real or apparent authority over the other, or where he stands in a fiduciary relationship to the other. रियल और अपेरेंट अथॉरिटी, यानी कि पेरेंट और चाइल्ड की जो रिलेशनशिप होती है उसको भी हम कह सकते हैं अपेरेंट अथॉरिटी. और फिडुशियरी रिलेशनशिप आपको पता होना चाहिए कि जैसे कि डॉक्टर पेशेंट है ना, ट्रस्टी बेनिफिशियरी का, ये सारे रिलेशंस जो होते हैं, ट्रस्ट एंड कॉन्फिडेंस वाले रिलेशनशिप्स जो होते हैं उसको हम कहते हैं फिडुशियरी रिलेशन, राइट? बी क्या कहता है? Where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age. चार चीजें, एज, इलनेस, मेंटल और बॉडीली डिस्ट्रेस. तो ये चार चीजों की, ये चारों चीजें क्या होगी, वो टोटली अफेक्टेड होगी, टेम्पररीली या परमानेंटली. So ये चीजें हो means when he's in holds a real or apparent authority over the other person or fiduciary relation, या उसकी मेंटल कैपेसिटी टोटली अफेक्ट हो चुकी है कोई भी तरीके से, एज हो गई हो ज्यादा या इलनेस हुआ है उसको कोई चीज का। इसमें है ना वो मेडिकल अटेंडेंट वाला चीज आ जाता है, वो लोग कभी कभी इसमें बेनिफिट बहुत ले लेते हैं ये वाले चीज में, राइट। जो नर्सेज होती है जो सर्व करती है पेशेंट को, राइट, दे मे समटाइम्स टेक द बेनिफिट इन सच अ केस, राइट। तो उसकी मेंटल कैपेसिटी या उसके बॉडीली डिस्ट्रेस की वजह से वो अपना रियल कंसेंट नहीं दे पाया, तो दैट्स व्हाई हिज कंसेंट वुड बी सेड टू बी नॉट अ फ्री कंसेंट, and that will say that the relations were existing between the parties in such a manner that there was the inducement of an undue influence on the other party, and that is why the other party gave a consent to it. Lastly, where a person who is in a position to dominate the will of another enters into a contract with him and the transaction appears on the face of it or in the evidence adduced to be unconsignable, yani ki unreasonable, the burden of proving that such contract was not induced by undue influence, yani ki burden of proof kiske uppar jayega, it shall be upon the person who is in a position to dominate the will of the other. अगर काजल ने मेरे ऊपर undue influence exercise किया है, right, और मैं कहती हूँ कोर्ट में आके कि you know why I gave this means I agreed to this agreement because I was under an undue influence, right? So काजल कहती है नहीं, it was not. So the burden of proof lies on Kajal basically to say it in the court that I did not exercise any kind of undue influence on this particular B person. Shall be upon the person who is in a position to dominate the will of the other person. Right? Nothing in this subsection shall affect the provisions of section 111 of the Indian Evidence Act 1872. आपने Evidence Act तो पढ़ लिया होगा. So they are saying it does not affect the provisions of section 111. अभी फ्रॉड क्या है, फ्रॉड का डेफिनेशन क्या है, इसमें बहुत सारे हैं 1 से लेके 5 तक। इसमें फ्रॉड इज डिसऑनेस्ट मिस रिप्रेजेंटेशन, राइट, और मिस रिप्रेजेंटेशन जो है ना सेक्शन नंबर 18 वो इनोसेंट फॉल्स रिप्रेजेंटेशन है। So fraud is actually dishonest representation, right? So fraud means and includes any of the following acts which are committed by a party to a contract or with the connivance or by his agent with the intent to basically इसमें क्या है, deceive another party thereto or his agent or to induce him to enter into a contract. बेसिकली इसमें इन लोग का मेन गोल है कि दूसरे पार्टी को डिसीव करना है और उसको उसके दूसरे पार्टी या एजेंट को डिसीव, उसके एजेंट को डिसीव करना है कि वो अपना वो इंड्यूस हो जाए और वो अल्टीमेटली कॉन्ट्रैक्ट के लिए हाँ करे। सो दे आर सेइंग, तो इसमें किस किस तरीके से फ्रॉड किया जा सकता है। फर्स्टली, द सजेशन ऑफ अ फैक्ट of that which is not true by one who does not believe it to be true, right? ये intentional wrong है, fraud is an intentional wrong है, means you say something, right, the suggestion of a fact of what is not true means आपको तो पता है कि ये true नहीं है and you also know it is not true by one who does not believe it to be true, right, but you say that it is true, you make the other person believe that it is true. The active concealment of a fact by one having knowledge or belief of the fact, right? You conceal a fact, you hide a particular fact, right? That is also means you are under the knowledge, you have the belief that it is you are concealing a fact, but you are doing that why? You want to gain an acceptance, that is why. So you will say you have committed a fraud. Thirdly, a promise made without any intention of performing it, you have no intention to perform it ultimately, right? So you will say that you have committed a fraud. By any other act fitted to deceive, कोई भी other act तुम्हारा main मकसद क्या है, to deceive the other person, that is known as fraud. Any such act or omission as the law specifically declares to be fraudulent. लॉ ने सपोजिंग कंपनी एक्ट है, इंसॉल्वेंसी एक्ट है, वहां पे उन्होंने ऑन द फेस ऑफ इट डिक्लेयर कर दिया है कि ये फ्रॉड्यूलेंट है और आपने अगर वो कमिट किया है तो आपको कहा जाएगा कि वो फ्रॉड है। Explanation: mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud. Mere silence is not fraud unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silent to speak, or unless his silence is in itself equivalent to speech. अगर उसकी ड्यूटी है कि उसको बताना चाहिए, राइट, नहीं तो उसकी साइलेंस इज इक्विवेलेंट टू स्पीच, तो वो माना जाएगा फ्रॉड. बट मियर साइलेंट, मियरली वो चुप रहता है, उसको हम फ्रॉड नहीं कहेंगे. दैट इज व्हाट इज फ्रॉड. इसको लेके आप ये देख लीजिए. डी, नहीं, सी देखिए. बी सेज टू ए, B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing. Okay, here A's silence is equivalent to speech. यानी कि इसको बोला जाएगा as per C, silence is equals to speech. So this will be considered as a fraud. They are saying if you do not deny it, means अगर तुम कुछ नहीं कहते हो, I shall assume that the horse is sound, means यहाँ पे A ने कुछ बोला ही नहीं उसके बाद, तो यहाँ पे उसकी silence was equivalent to speech. So that is why it becomes a fraud as per illustration C. Now see illustration D. A and B being traders enter upon a contract. A has private information of a change in price which would affect B's willingness to proceed with the contract. A के पास कोई information है कि ऐसे कोई prices में change आएगा जिससे B का willingness to contract affect होगा. A is not bound to inform B, not bound है. It is right. ये कुछ चीजें आप याद रखना, ये कुछ illustrations है जो उनके, right? सेक्शन नंबर 18, मिसरिप्रेजेंटेशन. फ्रॉड जो था सेक्शन नंबर 17, दैट इज एन इंटेंशनल रॉन्ग, बट यहाँ पे मिसरिप्रेजेंटेशन जो होता है वो इनोसेंट फॉल्स रिप्रेजेंटेशन है. मिसरिप्रेजेंटेशन मीन्स एंड इंक्लूड्स क्या क्या चीजें. फर्स्टली, द पॉजिटिव assertion in a manner not warranted by the information of the person making it of that which is not true though he believes it to be true. मीन्स उसको लगता है कि ये ट्रू है इसलिए वो कहता है, राइट. सो देयर इज अ पॉजिटिव assertion. सेकेंडली, any breach of duty without an intent to deceive gains an advantage of the person committing it or anyone claiming under him by misleading another to his prejudice or to the prejudice of anyone claiming under him. So without any, there is no intention yahan pe, but he gains an advantage. So you will say this is a misrepresentation. There is misleading over here. And lastly, causing, however innocently, a person to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement. Means innocently, the main substance of the agreement which exists, he innocently says something which the other person ultimately agrees it to be true. See, misrepresentation may be quite innocent, but when a false representation is made with the intention to deceive, वहां पे फ्रॉड में क्या होता है, इंटेंशन होना चाहिए डिसीव या डिफ्रॉड करने का दूसरी पार्टी को, देन मिसरिप्रेजेंटेशन इज अ फ्रॉड, राइट. रिमेंबर दैट. अब दिस इज वेरी इंपॉर्टेंट. 13, 14, देन 15, 16, 17, 18, राइट. CUFM. अभी यहाँ पे जो 19 है ना, 19 और 19A, they are talking about voidability of agreements without free consent. उन्होंने डाल दिया है this is section number 19 is with respect to coercion, fraud and misrepresentation. Okay, and section number 19A is power to set aside contracts which are induced by undue influence. So 19 is with respect to coercion, fraud and misrepresentation, and 19A is with respect to undue influence. So what is 19? Voidability of agreements without free consent. When consent to an agreement is caused by coercion, fraud or misrepresentation, the agreement is a contract which is voidable at the option of the party whose consent was so caused. So you can, मीन्स द पार्टी जिसके ऊपर अगर काजल ने मेरे ऊपर कोर्जन या फ्रॉड या मिस रिप्रेजेंटेशन एक्सरसाइज किया था, सो आई हैव द पावर, राइट, टू एक्चुअली means I have the power to set aside the contract. Means I can make the contract voidable. It is at the option of me to make the contract voidable. A party to the contract whose consent was caused by fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed, right? And that he shall be put in the position in which he would have been if representations were being made true. Exception. If such consent was caused by misrepresentation or by silence, fraudulent within the meaning of section 17, the contract nevertheless is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. यानी कि ड्यू डिलिजेंस के थ्रू अगर वो उसकी सच्चाई मालूम कर सकता था तो voidable नहीं है. That is what is exception. Explanation of fraud or misrepresentation which does not cause the consent to a contract of the party on whom such fraud was practiced or to whom such a misrepresentation was made does not render a contract voidable. यानी कि काजल ने तो मेरे ऊपर ये फ्रॉड या मिसरिप्रेजेंटेशन एक्सरसाइज किया था, लेकिन कोई थर्ड पार्टी ने उसको सुनकर, मींस इफ अ पर्सन इज जस्ट स्टैंडिंग नियर बाय या वो एंटर करता है रूम में और वो भी वो सुन के वो हो जाता है कि चलो हाँ लेट मी एंटर इनटू अ कॉन्ट्रैक्ट, पर काजल ने तो वो थर्ड पार्टी के ऊपर एक्सरसाइज नहीं किया था ना फ्रॉड या मिसरिप्रेजेंटेशन, राइट? सो his consent was not caused by this third party's consent was not caused by any kind of fraud or misrepresentation. That is what they are saying in explanation. Then you will say that the contract is not voidable because the fraud or misrepresentation was not exercised on this third party. It was exercised by A on B and not on C, right? 19A, power to set aside contracts which are induced by undue influence. When a consent to an agreement is caused by undue influence, the agreement is a contract voidable at the option of the party whose consent was so caused. Any such contract may be set aside either absolutely, first, it can be set aside absolutely, or if the party who was entitled to avoid it. Yani Kajal made it to me and I was entitled to avoid it. I could have set it aside, but I have received some benefits under it, right? Upon such terms and has received any benefit thereunder upon such terms and conditions as to the court may seem just. So you can either set aside absolutely, but if you have got any benefit to it, right? So you can either order, the court can order either any kind of compensation or any kind of restoration. Now agreements are void when both parties are under a mistake as to a matter of fact. So 20 and 21 are with respect to mistake. So 20 says where both the parties to an agreement are under a mistake as to a matter of fact which is essential to an agreement, the totally agreement is void. There is a mistake of fact, right? An erroneous opinion as to the value of the things which forms the subject matter of the agreement, right, is not deemed to be a mistake as to the matter of fact. Means with respect to a value of thing, कोई पर्टिकुलर जो कि एक सब्जेक्ट मैटर है टोटली अग्रीमेंट का, how can you just claim it as that it was a mistake of fact? That does not fall under mistake of fact. 21 क्या कहता है as to mistake of law? 20 is with respect to mistake of fact, 21 is with respect to mistake of law. A contract is not voidable because it was caused by a mistake as to any law which is in force in India, but a mistake as to a law which is not in force in India has the same effect as a mistake of fact. Yani ki you cannot take any excuse with respect to Indian laws, right? Yani ki you cannot say that I was mistaken that this law, this Indian law is applicable or this Indian law is not applicable, right? So then that is voidable. That contract, that agreement, and that contract becomes voidable. Sorry, okay, not agreement, because there is nothing known as a voidable agreement. There is always a voidable contract. So the contract is voidable if it is with respect to a law which is not in force in India. Then the same thing which falls under mistake of fact comes into play, yani ki section number 20. But you cannot take the excuse of mistake of law which is in force in India, because laws which are in force in India, it is accepted and it is demanded that every person should be aware of the laws which are in force in India. So you cannot take that benefit that I was not aware of this particular law existing in India. Contracts caused by mistake of one party as to a matter of fact. A contract is not voidable merely because it was caused by one of the parties to it being under mistake as to a mistake as a matter of fact. यानी कि unilateral mistake. 20 is bilateral mistake of fact. अगर there is bilateral यानी both the parties are under a mistake of fact, then the contract is void. Okay, but mistake of law is valid. Exception is foreign law, right? And 22 is unilateral mistake of fact. That is also a valid contract. It cannot be a voidable contract. So 20 is bilateral mistake of fact, 21 is mistake of law, and 22 is unilateral mistake of fact. Okay, यानी कि एक तरफी. What considerations and what objects are lawful and what are not? The consideration or object of an agreement is lawful, right? Unless firstly it is forbidden by law, means it must not be illegal. What they sorry I, When we read consideration, we said that it must not be illegal, it must not be unlawful, it must not be against any kind of public policy वगैरह, right? So they are saying over here, unless they are saying the consideration or an object of an agreement is lawful, it has to be lawful unless it is forbidden by law, or it is of such nature that if permitted it would defeat the provisions of any law. Means अगर उसको permit किया तो कोई provisions है law के उसको defeat करेगा, नहीं तो वो fraudulent है, means object या consideration fraudulent है, or it involves or implies any kind of injury to the person or to the property of another person, or that the court regards it as immoral or it is opposing the public policy. So अगर ये सारी चीजें होगी, right, then we will say that the consideration and the objects are unlawful. नहीं तो एवरी अग्रीमेंट के अंदर कंसिडरेशन या ऑब्जेक्ट लॉफुल ही होना चाहिए. लेकिन अगर ये चीजें एग्जिस्ट करती है, means it is immoral, it is declared by the court to be immoral, it is declared by the court to be opposing the public policy or causing kind of injury to the person or property वगैरह, so we will say that it is void. In each of these cases, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is said to be a void agreement. According to section number 23, अगर आपका ऑब्जेक्ट या कंसिडरेशन अनलॉफुल हो जाता है तो आपका अग्रीमेंट वॉइड हो जाएगा एज पर सेक्शन नंबर 23. इसके अंदर बहुत सारे इलस्ट्रेशंस है, आप देख लीजिएगा. कोई ऐसे कुछ आपको इलस्ट्रेशन समझ ना हो तो आप मुझे पर्सनली आप मुझे मैसेज कर देना, मैं आपको ऐसे समझा दूंगी, बट राइट नाउ वी डोंट हैव दैट मच टाइम. 23 agreements void. No, sorry, that was 23 only. We'll stop here, we'll start tomorrow because this is another new topic only, and I'll try and just rush through everything tomorrow maybe, but we'll stop over here only. Just go through it जितना भी हमने अभी किया है. We'll stop here and एक बार go through कर लेना. It's very simple only. आप एक बार देख लीजिएगा सारा का सारा. Tomorrow also I'll take the class at 11 only. Okay, we'll stop here.